And it never really made sense to me that documents that are public and that everyone has agreed years and years of case law on this are public somehow should be less public because they can be available on a remote access on your home computer or on your office computer rather than having to trundle down to the courthouse and get them. And what I fear is happening, as was mentioned, is we're now going to wind up with different classifications of documents. There'll be the public documents that are public to everyone in whatever form, whether it's on the internet or going down to the courthouse. And some people believe those should be very limited, although I'm not in that category. Then there'll be the ones that everyone agrees there may be a compelling reason for sealing, which is what the law requires. There has to be a compelling interest, and the standards have been pretty clearly set out by all the courts, from the U.S. Supreme Court down, so there are very few instances where that is satisfied. And then somewhere in the middle, there seems to be this split of opinion on whether there should be some documents that may be public, but we really don't want people to see them, and so we'll only make them available in the musty basement of a courthouse that you have to go down yourself and see. And while I think the electronic access movement is fantastic for journalists and for lawyers who may not have the resources to send someone down to the court every time they want to look at a pleading, it bothers me that we now are winding up in the situation where, in order to get the resources that the internet has made available, that you may be trading off access rights. And I think that would be a place that we really shouldn't go.
Okay.